We're sure. All right. Hi, Mr. Dorfman. How are you?
I'm very good, thank you.
I was
The mic's not on, Mr.
Can you hear me?
Yes, sir.
Mr. Dorfman, we were looking at Exhibit 335 that was introduced by your counsel, or counsel for Mr. Paxton. Can you pull that up for me, Stacy? No.
Check your mic one more time. It doesn't sound right.
Is it not working?
No, it is now, but you're tall enough that you're going to have to bend down a little bit.
Yes, Mr. President. Is this the memo that you were talking about on 335 with the council a moment ago?
It's one of them, yes.
And this memo was created by Chris Hilton,
I believe so, yes.
one of the lawyers standing over there, sitting over there?
Sitting, yes.
Sitting, yes. When you got this memo, were you shocked
By what?
by the fact that Mr. Hilton was attempting to usurp the power of Ken Paxton by removing his name from the letterhead?
No.
Did it appall you?
No.
Was it simply a matter of Mr. Hilton picking out this letterhead that is available to every employee of the AG's office?
I think you'd have to ask Mr. Hilton about that. I don't know.
You talked about the internal investigation that was conducted by the Attorney General's office, correct?
Yes.
And you talked about the fact that it needed to be fair.
Yes.
It needed to be unbiased.
Well, it needed to be objective, I think is the word I used.
And the subject of that investigation was Ken Paxton.
One of the subjects of that investigation.
It certainly was a big part of it, right?
The allegations against him were a big part of it.
Your Honor, may I approach the witness?
Thank you.
Mr. Dorfman, I am showing you what has been marked as 524, Exhibit 524. Do you recognize this document?
Give me 1 minute to read it quickly. Can you restate your question, please?
Yes, maybe I can make it easier. You see your email address right there, halfway down the page?
I do.
This is an email exchange that you received, you were on,
Yes.
and so as a result, you recognize this document.
Yes.
And, to use a predicate that's being laid by your counsel, this fairly and accurately represents the email as well as the attachment.
I think that's right.
Your Honor, at this time, we offer Exhibit 524.
Any objection?
Yes, Judge, I'd object to hearsay, and they haven't provided a proper foundation for this witness to sponsor this document.
Your Honor, we have a business record affidavit that overcomes hearsay. That gets by that, and the predicate is this witness was part of this email exchange, is a proper sponsoring witness, testified it fairly and accurately represents the email exchange that he was a part of.
Judge, I'm just confused. I don't have a copy of a business record affidavit.
You do have a copy of the business record affidavit. I didn't hand it to you, but if you want, I can get it for you.
Well, that'd be great. I think part of the rule is that it's, got to be provided to counsel, so that would be good.
I will,
Would you provide him a copy?
yes.
Judge, if I could just have a moment to look at the business record affidavit.
Take a moment.
Thank you.
Your Honor, I assume we're stopping the clock, respectfully?
Judge, I don't see why it should. They're offering it.
If it's a minute, we're not stopping the clock, but if it's longer than that, I'll stop it.
Judge, I have to reurge my objection. This business record affidavit is not the correct affidavit for these documents. It references Office of Attorney General numbers that are just not contained on the documents that counsel has provided me. And so I can't verify that it's the document that he's purporting it to be.
And we don't have a copy either of the business affidavit.
I can get you a copy.
That would be good. Yeah, it's supposed to be attached so that we know.
I appreciate that, Your Honor. It was attached to a bigger swath of documents. This is just one of the documents that's part of it.
We will stop the clock and give you credit for a couple of minutes here. Mr. Dutko, I will say I stopped the clock, but when either side has not been ready to present us what is needed, we have not stopped the clock previously. So I've given you 2 minutes here, but I don't know how long you're going to take.
Yes, Your Honor.
It does not seem you have your paperwork together.
Yes.
So can we continue and get the clock running and come back to that if you'd like?
Yes.
All right. Resume the clock, resume your questioning.
May I proceed? Mr. Dorfman, when you were on direct examination, you spent a lot of time talking about the fact that the quality of attorney that is currently at the Attorney General's office. You remember that?
Yeah, I think so.
And you said how you were proud to walk through the halls and the lawyers and the high caliber of lawyers.
I don't recall saying that. It's certainly true, but I don't recall saying it.
And you were talking about how good the lawyers are and how hard they work. Do you remember that?
Yes.
Yet, despite the fact that there's the high quality of lawyers that currently exists at the Attorney General's office, Ken Paxton had to hire Louis Brisboe as outside counsel.
Didn't have to, he did.
And it was certainly something that could have been handled internally.
I'm not going to agree with you on that. Now, I have an explanation why.
Okay. Are you aware of the fact that Louis Brisboe has billed the Texas taxpayers $524,000 for the work that was done?
Yes, I am.
And that doesn't bother you?
I think I've been very clear that I view the Texas fisc as a sacred calling for us. That's very important for us to preserve it and spend it wisely. Again, I had a reason why I supported the hiring of Louis Brisboe as outside counsel. But part of the motivation for settlement was to stop paying Louis Brisboe as outside counsel.
Your Honor, we have the business record affidavit that we were going to present to opposing counsel.
Okay.
Is this for this document? Yes. He's got extra copies of VRAs on. Again, Judge, I got to re-urge the objection. The document that they've handed me doesn't have a single Bates label on it, and this business record affidavit talks about Bates label documents. No way for me to verify the validity of these documents.
Your Honor, just so we're clear, these are documents that
Could I have a copy of that?
Yes.
And before you answer his objection, let us look at this. We're ready to resume. I'm going to sustain the objection because we don't find a way to identify this affidavit with the document.
Yes, Your Honor. Remember when you talked about the plea to the jurisdiction a little while ago?
Yes.
One thing is clear, a plea to the jurisdiction stays the case.
Once it's denied or granted.
Right, and so when you filed that plea to the jurisdiction, you, as the Attorney General's office, knew that the case would be stayed.
Yes.
That meant there would be no written discovery.
Yes.
That meant there would be no deposition discovery.
Right.
That means that Ken Paxton did not have to testify under oath for the entire time that that plea to the jurisdiction was being determined.
No one had to testify, yes.
Right, but Ken
Or
Paxton
got to.
didn't as well,
Yes.
right?
Yes.
And so when you filed it, you knew that was going to happen.
Once a ruling was made, yes.
Right. And even though you lost at the trial court, instead of going back to the case and conducting discovery, you appealed it to the Court of Appeals.
Well, we didn't lose the case at the trial court. We lost the plea.
Right, you lost the plea to the jurisdiction.
We disagreed with that and we appealed it, yes.
Which means that when you lost that case, that plea to the jurisdiction, that meant if you did not appeal it, you could go back to the trial court and take discovery.
If we chose not to appeal it,
Right.
I suppose that's true.
And then you appealed it
We did.
and lost.
We lost in the third court.
So then, instead of going back to the trial court to conduct discovery, where Mr. Paxton would have to give his deposition, you took a flyer and took it to the Supreme Court.
I disagree with you that we took a flyer. We urged the constitutional separation of powers, which is a pretty important constitutional doctrine, and we also relied on the sovereign immunity of the state, which this body thinks pretty importantly of as well.
Right, and then while the case was pending at the Supreme Court, there was an appeal, election, right?
Yes.
And after the election, before the Supreme Court, where you said you had a good faith basis to go, immediately after that's when you guys settled, right?
Not immediately, no.
Shortly thereafter.
We settled 3 months later, a little more than 3 months later.
Your Honor, I was told that the document that was printed for everybody had the Bates label that ran off the bottom, and so now I have a version that has the Bates label that identifies it as a document within the range on the Attorney General's, on the business record affidavit. Since it was a short notice, I have one copy. I would like to show it to opposing counsel and then bring it to the court, if that is okay.
Can I see it first?
Yes, Your Honor.
You can come forward if you like. Come forward if you like. You all can take a stand-up break, but don't leave because we're moving forward. Members, please take your seats. Give them a second to settle down here for a moment. You may continue.
Mr. Dorfman, I'm going to make this short because everyone's ready to be done. You started in December of 2020.
That's a yes.
And when you started, all of the whistleblowers had already been fired or resigned, correct?
Yes.
You didn't interview Mr. Vassar.
No, I did not.
You didn't interview Mr. Bangert.
No.
You didn't determine the veracity of what their testimony is in front of this Senate.
I haven't been allowed to watch their testimony, so I don't know.
Right, but you didn't determine the truthfulness of what they were saying.
To the Senate?
No, as far as the whistleblowing allegations.
We took their pleadings at face value and addressed those in the report.
I appreciate that, but you didn't make a determination yourself.
I never interviewed them, but the report is I don't know if you call it a determination, it's a report of our office.
Right, but when it comes to determining personal knowledge about the allegations that are made here in the Senate,
Yeah.
the allegations that are made before you got there, your testimony would not be helpful as far as personal knowledge goes.
I have no personal knowledge of what happened. I didn't hear any conversations in September or October or prior to that at the agency. That's true.
Pass the witness, Your Honor.
No redirect, Your Honor.
Can we excuse the witness, both sides? We're
Yes,
good?
Judge.
Thank you, Judge. Mr. Busby, who is the next witness?
Your Honor, Attorney General Ken Paxton, res.